Ready. Start. Quorum, Honorable Miss Justice Geeta Gopi. Date 6 7 2021. Oral Judgment. By way of this petition, filed under Section 482 of the Code of Criminal Procedure, the applicant has prayed to quash and set aside the proceedings of criminal case number of 2009 pending before the court of learned judicial magistrate first class Jam Jodhpur, along with all consequential proceedings. The fact in brief are that on 27 February 2019, the respondent number 2 herein original complainant filed a complaint against 1. Govind Bhai, Bhikhu Bhai, Hira Bhai, Karena in the capacity of being a partner of Messrs. Mehul Construction Company under Section 138 of the Negotiable Instruments Act 1881, for short the NI Act, before the Court of Learned Judicial Magistrate First Class Jam Jodhpur inter alia, alleging that he had advanced 3 lakh in cash to the said accused towards repayment of the said loan amount. The accused had issued a check of the said amount on 7 December 2018. However, the same got dishonored on the ground that the account was already closed after following due process. The complaint in question came to be filed before the magisterial court. It is the case of the applicant that the complaint in question is bereft of relevant details and particulars which constitutes the ingredients of the offense punishable under section 138, read with section 141 of the NI Act, and that the complaint would not be maintainable since the partnership firm in question, MS Mehul Construction Company, has not been agreed as a party in the proceedings. It is the further case of the applicant that said Govindbhai, Bhikhabhai, Hirabhai, Karena was an erstwhile partner of the applicant company and that by way of deed of modification in partnership dated 26 May 2017, four of the partners had retired from the partnership firm. The said accused was a party to such deed of modification in partnership and thus with effect from 26 May 2017 the said accused had retired from the applicant company. Learned advocate Mr. Vyas for the applicant company submitted that in view of the deed of modification in the partnership, the retirement form, the applicant firm was made by way of notice published in a local daily named Ajkal on 6th November 2017, which has wide circulation in the districts of Jamnagar, Rajkot, Ahmedabad, Porbandar, Bhavnagar, and Bhuj. It is further submitted that the applicant firm has not been made an accused in the complaint in question and therefore the proceedings against the applicant firm is neither legal nor proper. It was contended that no offense is made out against the applicant since the bank account of the firm is not maintained by the applicant. The complaint in question is also hit by the provisions of limitation and is not in consonance with the provisions of section 138 read with section 141 of the NI Act. The averments made in The complaint do not disclose that the check was issued towards discharge of any debt or liability. The statutory notice is not duly served upon the firm. Instead, it has been misused and the pendency of the criminal prosecution against the applicant would seriously prejudice the rights of the applicant. It was therefore prayed that the application may be allowed by quashing and setting aside the impugned complaint and all the consequential proceedings, though served, none appears on behalf of respondent number 2 original complaint heard learned advocate for the applicant and learned additional public prosecutor. The certified copy of the complaint in question and the order passed below exhibit 1 are on record. The cause titled of the complaint prima facie reveals that the applicant Messrs. Mehul Construction Company, which is a partnership firm, has not been joined as an accused in the complaint. The applicant is shown as an accused, but his status is not referred to be as for and on behalf of the firm.